versus Steve Lonegan and Robert D. Pasqua, and also versus the state of New Jersey. It's docket number MER-L-1933-13. As we did the last time, we'll take the appearances of those in the courtroom first, and then we will hear who's on the phone today. So on behalf of the plaintiff.
Good morning, Your Honor. Eugene Pro Se.
And for the state of New Jersey.
Good morning, Your Honor. Donna Kelly, Assistant Attorney General for defendants, Governor Christie and Lieutenant Governor McConnell.
Good morning, Your Honor. Peter Slocum, Deputy Attorney General, also for the state defendants.
Hey, I missed your last name.
Slocum, Your Honor. S-L-O-C-U-M.
Oh, okay. All right. And do we have a county official, counsel for county officials on the telephone? Hello? Did you have a number for us? Yeah. I pressed the button that you pressed for getting them off mute. Is it big on mute? Did you have a number for him? I think technical difficulties. You know what can I go for you, please?
Yes.
It's just a full time. Okay. This was the number he gave you for, they may still be on the call, but if we just give it to that, if we were on mute.
Hello, this is Judge Bilal.
Yes, this is Judge Jacobson. We lost contact with the conference call.
Okay, yeah, I thought we were on hold because we never heard a dial on anything that we've been disconnected.
I tried to unmute the phone and perhaps I disconnected you or perhaps it had been previously disconnected. Is there do you have a call-in number for everyone that I can call and access the group?
No, actually, I had contacted our county council this morning just to see if he'd gotten any of those details like we did last week, and he said that he hadn't and asked me to reach out to the other county councils. I sent an email, I didn't hear back from anyone. I contacted Janet, who is in the Cape County Council's office, and she's the one who coordinated the conference call last time we provided the call-in number. And so then I called Emily, and she connected me with the courtroom, or at least was going to connect me with the courtroom, and that's as far as we got.
Okay, so you're just calling on your own and you're not even the attorney, is that correct?
Oh, I am.
Oh, you
I am.
are?
I'm Deputy County Counsel.
Okay, I'm sorry. I wasn't sure if you were the actual county clerk or not. So then you can certainly, you can just go forward, and if no one else sought to participate, then we'll go forward with who we have.
Okay.
Okay? All right, well then I would invite you to place your appearance on the record.
Certainly, Judge. Joseph Bilal, B as in boy, I-L-A-L, Deputy Middlesex County Counsel, representing Middlesex County Clerk Elaine Flynn.
Okay. Ms. Kelly, did you hear anything in terms of any participation today by any of the county clerks?
No, Your Honor, it was just interesting though, there were other people on the conversation with the deputy counsel when we were waiting for you, but I guess it was just people within his office. But I have not heard directly from any of the county counsel.
Okay, there was no one else on the call with you, Mr. Bilal?
Judge.
Okay, all right, well then you're the interested one. So we'll move right along then to the argument. So Mr. LaVergne?
Good morning, Your Honor. We're here within 72 court hours, including weekend, of Your Honor's decision mid to late afternoon, Thursday, October 3rd, where Your Honor ruled on the basis of my application, he made findings of fact and conclusions of law that NJSA 19:5-1 and 10% provision in that statute in fact applied to special elections. Your Honor then made a finding of fact that is a matter of fact and law. Mr. Lonegan, the Republican's candidate, failed to meet the standard in 19:5-1. And Your Honor therefore made a finding of fact and the conclusion of law that Mr. Lonegan was not entitled to participate in the clerk's drawing or otherwise to be placed in a separate party column ballot. That is, in fact, the sum and substance of the first part of Your Honor's decision. I don't think anyone can reasonably dispute that. Long story short, Mr. Lonegan and the Republicans are not entitled to a separate party column on the general election ballot. The problem, as Your Honor couched it at that point, was the issue of revenue. And the problem is that always becomes the critical issue in these cases once a violation of law or a right to relief has been shown. That being whether or not meaningful timely relief can actually be provided. Now we can go through all the cases. The United States Supreme Court with federal constitutional violations has ordered ballots for an entire election to be redone within 5 days of an election. We know that the New Jersey statutory scheme itself contemplates changes to be made within at least 10 days of the election based upon 1930s technology, because we know that, for example, if a candidate dies 11 days before the election, they can substitute the name of that candidate. If they die 10 days before the election or 9 days, a dead guy or woman is on the ballot, and whatever happens, and if they get elected, then they have to have a special election. Now again, it's important to put in context, because I want to put what I'm doing here in context. The statute that we're dealing with was based upon 1930s technology. In 1930s, people used hand typesetting, or if they were lucky, they had a line type machine. So printing and things like that took a lot longer back then, but yet they still managed to turn out daily newspapers rather frequently in the cities. Most newspapers at that time were weekly because it took a long time to typeset.
One thing I'm going to ask you is that, I think I heard this the last time, so I'd like you just to focus on what's different. It's not a rehash of the last
Absolutely.
time, and you have provided some additional information to the court. So I'd like to hear what's different and why what you have provided to the court should lead to a different application, different result, and different application of the balancing test under the injunctive relief test.
Your Honor, after making your ruling, was unsure as to whether or not there would be adequate time as of mid-afternoon, October 3rd, with an election 13 days away. And so, since that was not, ironically, raised as an issue by any of the defendants, and all the paperwork that was filed, as I pointed out, my reply was essentially, oh, Judge, we've done all this printing. No one said it couldn't be done. They just said they didn't want it to be done, at least in their paperwork. Then, when Your Honor agreed with me that I was correct about the law, the next question Your Honor most appropriately asked is, well, all right, Mr. LaVergne's right, what can we do about this, if anything? And of course, as I point out in my reply papers, I had an in-depth discussion prior to coming to court with Mr. Appellate. So while I don't want to espouse hearsay, I have no intention of it, I knew how long it took. So when they started making representations to the court, that, which the finite representation was accepted by the court, which was proffered by Ms. Kelly and joined in by everyone else, was that it would take, quote, at least 2 weeks to do just the machines. We're not talking about ballots or any of those things. It would take at least 2 weeks just to print the 7,000 faces for the electronic machines, to slide it in and replace them, and to reprogram the machines, which, by the way, are 1990s technology. They use tape. It's not even digital. They were purchased in 2004. It's 1990 computer technology. It's stuff that today an 11-year-old would do. I knew it was very quick because I was told. I knew how long it would take, and it would take about 2 to 3 days tops to do all the machines in the state. I did not know at that time, since I had no reason to raise that issue or inquire for that issue other than informally for my own informational purposes, that was going to become an issue because I clearly understood it to be enough time. And in light of the fact that the Attorney General had filed a separate lawsuit, which is returnable before Your Honor tomorrow at 2 o'clock, where they said, we need 2 weeks, having 13 days, I figured would be enough. Based upon what I knew from Mr. Appel, because frankly, 2 to 3 days is really all you needed. So if they're saying in the other case it's 14 days, I thought the court could have granted relief. At the very least, the court could have granted relief with regard to only the machines and, if possible, the sample ballots, and even that's not important, the sample ballots, because the statute which has been violated, and it's not a technical violation, it's not a suggestion, the legislature didn't say do it if you can, is a statute that requires that the official ballots be configured this way. They use the specific word official ballots. An official ballot is, of course, by definition, not the same as a sample ballot. Sample and official are different words, different meanings, different places in the dictionary. So a sample ballot, while obviously preferably mirroring what is going to be on the machine, is not by law required to mirror what's on the machine. And, more importantly, the statute specifically applies to the actual official ballots. So there is a middle ground that the court can apply. I recognize, as I said last time, and if I didn't make it clear, I'll make it clear now, with regard to the overseas ballots, there's nothing that can be done. With regard to the printing of the, what we used to call them absentee ballots, now they're vote-by-mail ballots, whatever you want to call them, they change them around. Same thing. I'm not asking that that be changed.
You did initially, though.
I did initially.
I mean, we have a sort of a rolling series of requests. Because you also asked that the entire election be done by paper ballot.
I asked that on the 13th. I didn't get into court until the 3rd. So the relief that's realistically available on September 13th is not the same relief that's realistically available on October 3rd. When I made that request, I didn't know that it was going to be 21 days. They got a little over 15 days to return date for them, so I had to wait 3 weeks. There's a reality that the court is overburdened as long. I'm not complaining about it. I'm putting it in context.
No, my only position is that they were responding to what you asked for.
I understand.
And you asked for something different than what your supplemental brief asked for. You changed your position on the law, although I did not accept your supplemental position. And then, based upon the middle position, which I found was an accurate interpretation of the law, then we sort of wound up with what could be done. And so, frankly, I thought at the time, back on October 3rd, I didn't say this out loud, but I considered requiring certifications to be filed addressing the technology. But it didn't seem to me at that time that there was enough time to have that process done, come back and be reviewed. So I did consider that.
I understand. It wasn't raised. But my point is, the state is using the issue that wasn't raised, and that was raised by Your Honor reasonably, sua sponte, after you said what can be done, to say, I should have known about this ahead of time, so you can't consider this new information under Rule 449-2. First of all, as a threshold legal matter, I would suggest that that's absolutely inaccurate, because this information is new. The court was unaware of it. I was unaware of it. Ms. Kelly was most assuredly aware of it. But to put in context, we don't have the transcript again, because it was only last Thursday. I quite clearly, and if I didn't make it clear then, I will make it clear again now. At that point last Thursday, when Your Honor was talking about middle ground, I absolutely and unequivocally abandoned my request at that point about everything except the machines and the mail-in ballots. And quite frankly, the sample ballots. And quite frankly, today, as a practical matter, even though I know with today's printing technology, they can review those sample ballots. But the statute says they're supposed to be mailed 8 days before the election, which is tomorrow. They all get mailed, they all get mailed tomorrow. Well, today's Tuesday. They all get mailed tomorrow. The point being, as a practical, fair, and equitable matter, and in a set of circumstances where the law can get the respect which it is entitled, the statute should be enforced to the best ability that it can be under the circumstances. And
One
under
of
the
the things about knowledge about the certification that you just gave me, back in the brief that you filed on October 1st, you actually had a footnote, number 5, at that time, October 1st, where you talked about issues, and that was about the rechecking of the machines, you know, in the brief submitted to the New Jersey Supreme Court in June of 2013. So even as of October 1st, you had access to the certification from June that you, or I think it was public, it could have been access. That's the whole point about reconsideration. You need to come in with
In the footnote, I believe I was not talking about the Discordia case. I was talking about the Discordia case, not this case. What documents are on referring to?
I'm referring to your brief of October 1st, footnote 5. This very issue was discussed in length and detail by DAG Donna Kelly in a lengthy brief submitted to the New Jersey Supreme Court in June 2013, where the Attorney General was opposing a request by another party that the New Jersey Supreme Court hear a challenge to a lower court's decision rejecting a legal claim that the special general election must only be held on November 5th, 2013, simultaneous to the regular general election. So I mean, you did mention it right there, and then you're giving me a certification for the basis of reconsideration from that case, which, you know, on reconsideration, you're supposed to the first time around have given me everything.
Well, let me clarify, Your Honor. With regard to my reference to the Attorney General's brief, there was a 53-page brief that was filed with the New Jersey Supreme Court. That's what I found online. Not referenced or attached to that. You will not find the certification or the appendix to that brief. That's in a separate area. But the brief itself, and that's why I gave the actual sites when I emailed the paperwork, because when I found the brief, I didn't find Mr. Giles' certification. I only found the brief, and quite frankly, when you're filing a petition to the New Jersey Supreme Court, which is a court with appellate jurisdiction, it wasn't within my contemplation that there would be any new information that would be provided in that filing, because the New Jersey Supreme Court was being asked to review what the trial court had done. The record from that, which was reviewed by the appellate division, affirmed by the appellate division, and then Giuseppe Grillo had asked the Supreme Court to hear the case. I was under no impression and had no understanding that new information was intended to be brought before the New Jersey Supreme Court.
But you see, it's whether the information is available or not. I mean, it's just one of the points on reconsideration. Frankly, I just noted because you had mentioned it, you knew about the case, and you know, it was in existence at the time you talked to papers.
Sure. Well, when I say I knew about the case, the Grillo certification isn't published in the New Jersey reports or New Jersey Super. It was in an obscure document, not even linked to the brief online that I was able to find after when I went looking, because when I was looking and doing research for the main case, which Your Honor heard on Thursday, the issue of how long it would take was not an issue. But I did find where Donna Kelly was making the exact opposite arguments in a brief to the Supreme Court, so I pointed that out. That brief I could readily find. But the point I'm making is when you're talking about new information, first you have to have had the issue before the court in the first place. And by that I mean the first time the issue was raised. It's not like you had an opportunity to go out and research and Your Honor said take a break. Or like you said, you carry the member to ask everyone, well, how long will this take? From the bench, the first time you said to the parties, including me, how long will it take? I had my understanding. So why would I, in papers, submit information to the court on an issue that's not an issue? In fact, you're just not even talking about things that aren't an issue because they're not relevant to the case. So why would I bring it forward?
Except in any election case, the practicality of reconfiguring the whole election process was clearly an issue for both sides. And you came and asked that everything be restarted, but you didn't give me specific information on how long it would take. So it clearly was an issue in my mind that arose from your very filing. And the fact it wasn't addressed by you and was not specifically addressed by the defendants, except in terms of their opposition to the global relief that you sought. They didn't parse it out and say, we can't do this in this time, we can't do that in that time. They just said, Moshari says you don't, once the draw is made, it's too late to do a redraw. That was their position. So they didn't parse it out, but they did tell me that they had sent out the mail-in ballots. They told me that they had printed the sample ballots, all of the number of ballots and so forth. So they did address the practicality of starting the whole process over. And then in the course of the argument, I asked some specific questions, and Ms. Kelly gave responses, and we had some of the county clerks. I remember the Hunterdon County clerk said that some of the sample ballots in Hunterdon had already been sent to the post office, even though they had until, I think, tomorrow to get out the sample ballots. Some of them had already been sent.
But to directly address your own point, because it's a transcript and it will bear out what I'm about to say. By the time we were talking about that finite time frame of 2 weeks, we were only talking about one issue, and that was the machines and the sample ballots. Because quite clearly, the overseas voter law requires 45 days. And quite clearly, redoing everything, notwithstanding the asking for it initially, I clearly, on the record, abandoned everything at that point, except the issue for the machines themselves and the sample ballots. There is no question that the record will bear that out. And as I stand here today, I'm abandoning, so that the record is clear, I'm abandoning everything except the request that the machines with the official ballots be corrected, because I know that can be done. And how do I know that? Because of information I was previously unaware of, that the court was previously unaware of, tells us it takes not 2 weeks, but 2 days. And that certification was certainly known about by Ms. Kelly, because Ms. Kelly drafted it, submitted it to the New Jersey Supreme Court. Your Honor may say, oh, well, we were talking about 2 weeks, we were talking about doing everything. No, we weren't. We were talking about the machines and the sample ballots. And now we know that it takes 2 days, 48 hours, from start to finish, according to Mr. Giles, to reprogram every machine in the state, which is exactly consistent with what I was told by Mr. Giles.
Now, what about did you receive the new certification from Mr. Giles?
Yes.
And so he addresses, gives additional information beyond what was presented in the June certification. And he mentions that he goes through the whole process, and I'm not sure this can be done in 48 hours because of the legwork that's required to get you to the point where it would take 48 hours. Let me see, he talks about the various steps would have to be undertaken if they were required to replace the voting machine ballots. It is not simply a matter of putting a new paper ballot face on the machine. Each individual voting machine would have to be reprogrammed. And
which takes 2 days.
I'm just looking here, talking about the cartridge created by the appropriate election office based on the ballots designed by the county clerk, set up by the printer on a gridded format. Each officer candidate is assigned a switch position on a graph. Talked about the ballot information being entered into a database. Any change in the ballot position for a candidate after the initial designation would require the county to redo the ballot programming for each machine. Once the ballot information is created, it must be downloaded onto the cartridge, which is uniquely identified by serial number and associated with a particular voting machine. Voting machine preparation also includes a setup diagnostics, or I guess it's the name of a company, setup diagnostics, test the functionality of the various components of the machine, or I guess I'm not sure if it's a what set of diagnostics is, I guess I'll have to look from Ms. Kelly, but that's performed. The ballot face must be placed on the machine with protective mylar cover. The machine cartridge is inserted. A pre-logic and accuracy pre-lab test is performed. And then there's things about additional emergency ballot box with paper ballots. Understanding the number of voting machines have already been prepared and ready for the election. Middlesex have already started shipping its machines and has would at least have them done 25% by the end of the day yesterday. At this point in time, any redoing of the ballot would force the counties to redo the voting machines. It's my view, the current election process, that it would be disruptive of the, it is my view that any disruption of the current election process could well defeat the fundamental goal of the electoral process, the full participation of the electorate. And, you know, he then addresses your allegation that that the certification, the June certification, I think he's relying on, is directly contradicted by representations made at the last argument. And then he goes on to discuss what led to his filing of the June, the June 2013 certification, requiring the amount of time between the October 16th election and the November 5th election in terms of getting the machines ready. It talks about an important component for the success of the November 5th election being the fact that the ballot design and programming was completed well in advance of the election. And let's see. And that in light of the legwork that they've done for the November 5th election, it would only be necessary to burn the cartridges and reset the voting machines so they can be tested, certified, and delivered for the November 5th election. And that they've already established expedited delivery schedule for the voting machines. And let's see. Okay, 9 days is not enough time. And that was from yesterday. Not enough time to do what the plaintiff requests, to conduct the ballot redraw, design the ballot, reprint and mail the ballots, reprogram and retest the voting machines with the new ballot, and deliver the voting machines to the polling places to conduct and order the election on October 16th. So I just wanted to put that in the record so that it was my understanding of what he's saying now to look at versus what he said in the certification in June of 2013.
May I hear?
Yeah, I just wanted to put it in the record, and then you have to respond to
Thank you,
what he said.
First, I mark this as P1. I'd like to make this part of the record. This is the actual certification of reason I want to introduce the evidence and make part of the transcript. P1.
You know, we don't take evidence here. I think we've already submitted it, so it is already part of the record. I believe that you attached it. Did you not? Let me just...
Yes, I did, but I want to make sure that this is attached to any transcript that ultimately gets generated, so there's no doubt as to what the document was.
Was RA, was that the state's appendix? That you
That was at the state's appendix, but I submitted. It starts at RA 34
Right.
and goes
So this is your appendix?
my document, correct. That's what I submitted.
Okay. Yeah, no, it's part of the record, it's part of your submission.
Now, Your Honor, let me address this. Everything Your Honor said sounds good. It's all a lot of gobbledygook white noise. Because what the state has done is try to implement things I'm not asking for and say, oh, we can't do that in 9 days. What Mr. Giles doesn't say is it'll take more than 2 days to reprogram and do all the ballot machines. He says, in 9 days, we can't reprint all the absentee ballots, the sample ballots, we can't do all that in 9 days. I'm not asking for that. We're here, Mr. Giles works right up the street, he's a state official. We have 3 or 4 certifications from him. Let Mr. Giles go under oath and rebut what he told the New Jersey Supreme Court. He told the New Jersey Supreme Court under oath, let me just read, quote, with regard to time frame to reprogram the machines, which includes the face to ballot. Quote,
You know what, let's get the paragraph, okay? I want to make sure I have this in follow.
Paragraph 32.
Paragraph 32, page 8 of the Giles certification from June of 2013, which is part of the record in this case attached to the appendix submitted by Mr. LaVergne.
Correct. Now, after we were told it would take 14 days, and to clarify, the transcript will say what it does. The 14-day time frame was to do the machines, not to do everything. It was the machines. That's what Ms. Kelly said. Mr. Giles, however, told the New Jersey Supreme Court by certification, quote, that's the time frame, supplemental staff members will be provided in sufficient numbers so that the voting machines throughout the state will be prepared for the November final election within 48 hours after the process begins, if necessary, regardless of whether the defeated candidate seeks to reject. That would mean that voting machines will be ready for shipment on November 2 at the latest. That's in the context of him, Mr. Giles, saying, what if I don't get the machines back till October 31st? He then goes on to continue to say, by using existing resources as well as extra resources that the state will provide, if needed, the machines will be deployed and received by the respective polling places in sufficient time for the November 5th election. Paragraph 33 starts, additional transportation resources staff will also be made available by the state, if necessary, to deliver the voting machines to the polling places within 48 hours. So what Mr. Giles said under oath to the New Jersey Supreme Court isn't changed by the certification that Your Honor has placed on the record, because the time frame of 9 days he's talking about to try and prevent what I want happening isn't limited to what I'm asking for. He includes within that 9 days the printing of the sample ballots and all sorts of other things.
But it sounded as if, at least I'm not versed in the technology of the voting machines. Unlike Judge Feinberg, I didn't sit to hear all that testimony, but the sense I got from the most recent certification that he filed is that there's a lot of legwork that needs to happen, and all of that would be done in advance for the November election. In terms of prepping the ballot faces and the things that I already read into the record, so that they could do it in 48 hours. And I don't know that he wasn't addressing that in the June 2013
Your Honor,
certification.
these machines, purchased in 2004, based upon 1990 technology, have been rejected and stopped being used in most states, such that you can buy these on eBay. And it takes to print, as long as it takes to print 7,000 sheets of paper, which Kinko's takes about 2 hours. That's printing the sheets of the ballot. They want to make it look like this is some type of special paper, like it's anointed with the aroma of unicorn methane or something like that. It's a print job that any printer could do. Kinko's, I know 10 printers could have it done in a couple hours. Then they take that, and they pull out the plastic, they pull out what's there, and they put it in what's there. And then all they got to do is reprogram the machine. You know how long that takes? According to Mr. Giles, 2 days. That's what he told the Supreme Court on June 18th. And he didn't rebut that in this most recent certification. And you want to know why? Because he can't. Because it takes 2 days. Now, the delay since last Thursday might have made their job more difficult by cutting out the extra time that they would can be done, it should be done. The law says it's supposed to be done. They don't get to ignore the law. It is not a technical violation. They come back with this anemic response, which Your Honor, Madam Mayor, take all this time to do all these things I'm not asking to have done. I'm asking to have the basis printed. I'm asking to have the ballots reconfigured. That is my application. And so the record is clear. Let me say it again. That's all I'm asking for. Because 19:5-1 mandatorily requires, when read parity with 19:14-12, that the Republicans and Mr. Lonegan not have a separate political party column.
Okay.
These are very significant, and with regard to the information, it is ironic because, again, it's kind of disingenuous for me to say, you know, Mr. Giles, and I'm coming in here saying that you should consider what I have to Mr. Giles. But the difference is what I have to Mr. Giles addresses the issue directly. The information that they want to provide, which they clearly could have provided and chose not to, which the court read into the record, talks about issues extraneous that weren't raised, but doesn't rebut what I'm saying. According to the information I have from the greatest expert in the country, again, I know how to remand, you're in charge of the Viscoria case.
And I also know that you haven't provided it to me on this application, so I don't have it. All I have are the 2 Giles certifications. I don't have any certification from any expert to support what you're saying.
Sure you do. Giles.
Other than Giles, and you're throwing names around that are not part of the record here, and conversations you have with individuals. I don't have that as part of the record here. It's not competent evidence before me.
I feel that it's background information as to why I continued to look when I was told it was 14 days, because I knew that was not accurate. And not only did when I continued to look, did I find something, I found something from the guy who's in charge in Iran order the relief to do this, saying it takes 48 hours. And the certification he submitted does not rebut that.
Okay, so I'm going to hear from Ms. Kelly. Thank you.
Good morning, Your Honor. First of all, I do appreciate, Your Honor, that you do not have the Christie v. Grillo brief in front of you. It is as Mr. the plaintiff here has indicated, you apparently got it off of the website. What I find really interesting is if you do look at the state's brief that was filed in the state Supreme Court in Christie and Grillo v. Christie, it does reference the Giles certification and talks about it extensively within the body of the brief from pages 39 to 44. So that further bolsters the state's position that this is not an appropriate motion for reconsideration because the plaintiff had this information that he could have brought forth in his initial application.
Well, he said he didn't have it, but the test is, was it available?
And
so, I mean, I accept Mr. LaVergne's representation. He didn't have it, but we don't take a subjective view of, for reconsideration whether you had or didn't have something. But he also makes the point, though, that the way the litigation has evolved, it wasn't so clear at the October 3rd hearing that we'd be focusing on what the machines could do. So I don't know, if, in light of that, perhaps I need to look at this on the merits rather than just say he doesn't meet the typical standard, because in the interest of justice, one can always relax. So
I will appreciate that, and that was my second point, Your Honor. Even if you did have before you last week the certification was filed by Mr. Giles in the Grillo case, it should not have made any difference in terms of the correct outcome, in terms of not delivering any relief for the October 16th election, because the certification was filed in the state Supreme Court in June is not contradictory to what the state has maintained in this case. The focus for the Grillo v. Christie certification was the voting machine issue. In that part of the process that we focused on was really what I would call, and I have called, the back end of the process for election preparations. The front end is really still what the plaintiff here is seeking, and it's a draw for ballot position, it's a reprinting, and it's a reprogramming of the ballots for purposes of preparing the voting machine. And that's clear in the certification from Mr. Giles that in order to program the ballot for the machine, it all had to be done at the time that you were doing the programming for all of the ballots. So that's all done internally with the computers, he indicated in his current certification.
Oh, but what about, Mr. LaVergne points to the section of the June 2013 certification of Mr. Giles, where he does speak about being able to, the training and certification is not complex. This is for people working with the voting machines. The voting machines are straightforward design. There are instructions provided for their preparation. Supplemental staff members will be provided in sufficient numbers so that the voting machines throughout the state will be prepared for the November 5th election within 48 hours after the process begins. So, I mean, it's not unreasonable for Mr. LaVergne to take the 48 hours, even if it's at the back end. Then that's not the back end. They're talking about the front end, that we concluded the October 16th election, and then he says we can get the November 5th election, get those machines ready within 48 hours.
But at
Isn't that the front end?
No. But I'll try to explain it, Your Honor, is that the way we look at the election preparations, starting with putting aside the nomination petition and the whole petition filing process when you get your candidates. Now you come to where you're going to do the ballot draw for ballot position. From there, you're going to be doing ballot printing. From there, you're going to be doing the programming of the ballots that will be printed for the mail-in ballot, sample, and the voting machine. That's all done. What that to us, Your Honor, is the front end of the pre-election preparations. And then from there, you're going to the voting machines. Now, the difference here is that considering what the plaintiff still wants, he's asking the county clerks to do a redraw for the ballot position, which would require a reprogramming internally before you can even get to the point of, burning the cartridges and preparing the voting machines. For the November 5th election, we've already done the ballot work. August 12th was the ballot draw. September 16th was the day that the clerks had to put the ballots to the printer for the printing. So that's all done. So what we're saying is, if worst case scenario is there's no recheck prior to the November 5th election, all that work will have already been done. We don't need to go back and redo that, which is what they're asking you, this plaintiff is asking you to do now. And the other difference here is that there has been, as indicated by Mr. Giles in the certification of yesterday, there's been a lot of advanced planning by the counties, knowing that we had a 3-week time period between the two general elections. So there's been additional planning, as he indicated, with dealing with municipal clerks and polling place, getting access to polling places, having your staff, additional staff ready to deal with this 3-week time gap. So that's why this, to us, Your Honor, this situation is not comparable to the November 5th situation. It's comparing apples to oranges, because we're not having to face for November 5th this whole stepping back and now doing a redraw, reprinting, and a reprogramming.
Well, that's the sense I got from looking at the two certifications, but Mr. LaVergne makes another point that Mr. Giles didn't segregate the time it would take to reprogram the machine. He lumped some things together and said it couldn't be done in 90 days.
The other point, too, Your Honor, he does have the certification that with Middlesex County, you already have machines on the road. You're already in polling places. He says that's in his own, we'll stick with what he said in his certification for one county. They anticipated having at least 25% in the polling places as of today. As of yesterday, actually, the end of yesterday.
What about his point that, that if we had a ballot access issue with a death, for example, in less than 10 days, I mean, I guess perhaps if it could be done, if it had to be done, it could be done.
I don't agree with that. I don't know what statute he's really referring to, but I know there was one statute on the whole point about something did happen, it's an old statute. I'm not aware of us being able to making ballot changes 10 days before an election. I'm not aware of that unless it's under a court order, to be very honest with you. I'd have to look at the statute again.
I know the other thing that was of great concern to me at the October 3rd hearing were inconsistencies inconsistencies between the sample ballot and the machine ballot. I know, I think at least maybe in the Judge Haynes decision, he had allowed it, but I was very concerned at the potential for voter confusion. And I was really struck that Hunterdon County, for example, had already sent a certain number of their ballots, sample ballots, to the, to the post office. And so I was concerned with, even if, I don't think I made a finding. I haven't gone back to listen to what I said, but we have the clerk's notes, and I asked my law clerk to listen, and I don't think I ever said it physically couldn't be done. I may even have assumed that it could be done if it had to be done, but I was looking at the balancing the hardship and the impact on the voting public of particular inconsistencies, certainly between the sample ballot and the official ballot.
And that concerns even greater now, Your Honor, so we're 8 days away from the election. And in Mr. Johnson's application, he does state that what the clerks provided to the court last week shows that 3,941,130 sample ballots were already sent out as of October 7th. So that, and now what they're looking for is to have that redone. And in terms of the sample ballot also matching the, quote, the official ballot, that is what the law does seek. It's 19-14-22. And again, I think it's what you heard from at least one of the county council last week, the whole concern that voters who do read their sample ballot look for a certain, position of their chosen candidate on the ballot, so that when they go into the machine, it'll be what they read before they got into the voting booth.
And, if, for example, the relief sought would violate one aspect of the elections law, which you said the sample ballot should match the official ballot, so the relief sought would violate that, but not giving relief would violate another provision. I had to balance. And what is your view in terms of the factors, in terms of balancing the harm to the electoral process? And not the factors, but how would you balance the concerns that we have here?
I think that right now, as we stand before this court, the concern is focused should solely be on the voters. The voters next week, on October 16th, next Wednesday, they expect to be going into their polling places, knowing that the machines are done and set, and that the machine face will reflect what the sample ballot has indicated. This is not a case where we have somebody who should have been on the ballot and somehow we forgot who's name on the ballot. He is on the ballot, and as also your Honor realized, I think, when you look at one of the sample ballots last week, it's clear. It's a simple, short ballot. The names are right there, the 8 names. I mean, it's not as if there's will be any voter confusion in that regard. I think there'll be greater voter confusion, potentially, if the sample ballots don't reflect what the machine says, and also if the court were to even think of considering the relief that he's looking for now. I really, 8 days away from the election, with machines already being in the polling places, I just really don't know how you can effectuate that, because again, it's not simply reprinting a piece of paper and putting it on a machine, because the name of the candidate is connected to a grid position that's in the machine, because the votes are all electronically recorded. And that is what Mr. Giles indicates in his certification, and that's how you program voting machines. This is not, a paper ballot system where we're just reading, manually reading somebody's checkoff on the ballot. I mean, the name has to be coordinated with a position in the machine electronically, so that when the votes come out, they are as the voters intended. So again, this is not a simple going to Kinko's process, Your Honor. And
the other thing that, I don't know if this may be more an issue for tomorrow, but I know that, for example, at one point, Mr. LaVergne had asked that all the, and maybe he's asked it in response to the application of the state about the rechecking of the machines that's performed tomorrow. But he had asked at one point for a complete paper ballot process. And we recently had a decision from the appellate division that remanded a piece of the challenge to the voting machine case to me because there had been a problem in Cumberland County. I think we discussed this briefly at the last argument. And so I know that Mr. LaVergne was very concerned about the integrity of the voting machines. He's underscored that today. But frankly, that was also in my mind when I was balancing the effort to get the placement right under the statute versus the integrity of the election. And when I will be doing a remand on the voting machines, I was concerned that rushing reprogramming was not a good idea, particularly at this point in time before I've had the remand and can see what actions the state has taken to assure problems that, like those that arose in Cumberland won't happen. And it was responding to a concern he raised about the integrity of the machines that was also in my mind in terms of, even if it could be done, even if the reprogram could be done from October 3rd to October 16th, or even from today, October 8th, it seemed to me as if it was better not to interfere with the reprogramming process in a rushed way as was being requested.
Yes, Your Honor, I think it'd be even more rushed today as we're standing here. And again, comparing the time frame between October 16th and November 5th, the state, the counties have already taken the advanced planning to add additional resources and staff to make sure that everything can be done properly, because that is our number one priority. Whereas we're not in that position at this point, especially since, again, the machines, are on the road.
The other thing that strikes me is that what's being sought here is to effectuate the ballot placement requirements of the state election law. But I don't have a record with any facts as to the impact of placement on the ballot and what the impact it could or would have on the election process. I've looked at the earlier decisions and the cases that Mr. LaVergne himself was involved in, either as a party or as an attorney, and there have been allegations made in some of those cases, even going back as late as 1999, I believe, in the Moshari case. But I don't have any facts here to demonstrate what practical harm there might be from the ballot placement. Do you want to, it's the position of a candidate placement on the ballot.
I agree, Your Honor. We certainly don't have any indication. And again, if I were a voter and if I, looked at a ballot and the font of one candidate was smaller than the other, or was larger, somehow it was unbalanced, it seemed unfair, or if you had all the candidates in one position and then somebody was separately out of a different line, then I could see a concern with the ballot placement. But that's certainly not the situation here. As Your Honor has in the record a copy of one of the sample ballots. So there hasn't been any real harm presented consideration for this court regarding this application.
I know that Mr. LaVergne had raised the point the last time, and it sort of underscores what he has said today, is that it's very frustrating when there is a violation of the statute. And for a court to find a violation and no remedy is also goes against the grain. But you pointed out that if I grant this relief, we'll have a different kind of violation. And so, is there any recourse? I mean, if there's nothing before the election, is there anything after the election in terms of an investigation by the superintendent of elections?
Well, certainly a party has the right to ask to contest an election. If you look at Chapter 29 of the statute, there are enumerated grounds upon which somebody could contest an election. I'm not sure I've ever seen one where it dealt with ballot placement, but nevertheless. And as for any investigation by county superintendent of elections, somebody who should properly have to come forth with a substantiated complaint that would lead consideration to an investigation. So it's not something that is done lightly, and it's not done with just a comment or an anonymous letter. It's something that somebody would have to really put in writing, give about a reasonable basis for a look at an election. Yes, Your Honor. But the other point too about the concern with finding violation of not being prescribed remedy, again, we'll go back to what we have said earlier in our papers, is that Mr. LaVergne was clearly, by his own statements, was aware when the ballot vote was taking place, and yet he waits 3 weeks, after the ballot vote was done by the county clerks. He has indicated he has some familiarity with the election process, so nothing was barring him from seeking relief at an earlier point in time, and that could have made all the difference. It could have. I'm not going to say it.
But he said he did not know the date of the draw because he could not find the timeline. You made the representation to me that the timeline was available as of July. I don't know if it was July 13th.
July 11th, but no. What I was referring to was the letter that he apparently sent to the county clerks, to all the county clerks before the ballot roll was done.
Right.
Telling them that, this is my advice, you should listen to it. And, he certainly could have, he claims he made an inquiry with one county clerk in Lonegan County. There's nothing in the record to show that it's true. But again, we believe this indication that he was aware of the process, had this particular issue on his mind around that time, and there was nothing that was foreclosing him from coming into it sooner. But we are moving on right now.
He had addressed that the last time.
Okay, that's fine.
And I think there's some little bit of differences. That's your understanding of what he said and my understanding. And he also mentioned that the delay was necessitated by our right to know request because that Burlington didn't release the sample ballot to him when he requested it. Things of that nature.
But the point being right now, Your Honor, is that we believe there's absolutely no basis for the court to grant this motion for consideration.
Thank you. Mr. Bilal, I know that, are you still there? Yeah. Mr. Giles's certification made specific reference to Middlesex County. I know that you didn't file any papers, but this was, I put this down for review today. And is there anything you wanted to place on the record on behalf of Middlesex County?
No, Judge. The statements that Mr. Giles said are consistent with the county's position, and my understanding is that Mr. Giles called our Board of Elections Administrator, James Goldbrook, yesterday morning, spoke to him. They discussed the details involved in dealing with the ballot machines, or the voting machines rather, and Mr. Giles used that information as part of the certification, and Mr. Vogel has reviewed that information and said that it's an accurate reflection of their conversation.
Okay, thank you. Okay, we'll hear from Mr. LaVergne.
Thank you. I'm sorry. I'm just not drinking the Kool-Aid, and I hope the court doesn't. All this stuff about the voters and all this stuff, they're so worried. The voters expect the machines are going to be done. Let me tell you something. I worked the Board of Elections since I was 18. I've done election recounts, election contests. I know what the voters expect. You know what the voters expect? That there's going to be a machine there at 7 o'clock when the tape the polls open. All the stuff that happens behind the curtains, they neither know about it nor care about it. That is the reality. So the question isn't whether the voters are worried about the machines might have to be brought back in 25% of Middlesex County, when we already know that 100% of New Jersey can be done in 2 days. So I suspect that can probably be done in a minute. The question is whether or not I'm asking for can be done. Because the court's not saying it shouldn't be done, and the court is not saying that I'm not entitled to believe because the law's in my favor. The court simply said they violated the law, can we do something about it? Now, Ms. Kelly made almost a disturbing point because Your Honor said, well, what else have you done post-election? Because they want to say, this is all my fault. The county clerks do a drawing 45 days before an election at 10 o'clock in the morning, when the only statute that authorizes the drawing says 85 days at 3 o'clock in the afternoon, and they were telling them about it after it's over. and suspecting that there's going to be a drawing, but not knowing when it's going to be, because I've been down this road before, like I used the example last time, it's like the guy in the seaside town that builds a 5-story house in a zoning area where you're only allowed to have 2, because once it's built, there's nothing they can do about it. Yet, they made a guy take one down when he did that. Why? Because it could be done. Okay? In this case, what do we have here? We have the wholesale violation of state election laws by 21 of the county clerks that has resulted in an illegal ballot configuration. It's not a de minimis violation. It is a clear violation of the statutory law. And if a remedy can be provided, it should be. And all this stuff about the voters being worried, let's go to what is before the court. Okay? If Your Honor is willing to consider the Giles certification of June 18th, what is before the court is, to use the phrase, back end, front end. It takes 48 hours to do what I'm asking. That's what it takes. And it takes another 48 hours to deliver the machines. Now, conceivably, is it okay to violate one statute at the expense of another? How do you make that judgment call? What's more important at the end of the day is the official ballot. Because it's interesting. Everyone wants to convert my argument into something that it's not. I'm not bringing this case as a ballot location case saying it's unconstitutional, the local so here on the left, we don't confine this vote. I'm bringing this case saying, hey, the law says this, not me, the legislature. And they've said it since 1930. These 21 county clerks have known it since they took office, because I've sued them before, including last year. So they can't say they didn't know about the applicability of 1905-1. And I parenthetically note, only 3 even have the audacity to argue that it doesn't apply to special elections, because it quite clearly does. And Your Honor found very quickly that it quite clearly does. And against this background, these very same county clerks all get a letter from me. And it's not just one. Read the certifications. Only one clerk, I believe it was Cumberland County, that I said, we never got anything from this over. And with all due respect to Cumberland County, they keep the records a little different down there. Everything in Essex and places like that is stamped and time dated. They're not going to try and tamper with that. I don't know what goes on in Cumberland. All I can tell you is they got a letter. Everyone got a letter. And they don't know about this because they all talk about it. They all have the same counsel, John Corbo. They know about this issue. They chose to ignore it. I didn't know that there was going to be a drawing. Because once again, the drawing they held was supposed to be 85 days before the election at 3 o'clock in the afternoon. Only they knew they were holding the drawing. I didn't know they were holding the drawing.
But if you didn't get anything 85 days before, you could have objected at that point, which would have been before they did the draw, and say you violated the statute already, but you didn't do that. I mean, so it's.
I said you can't do that. Judge, what I'm saying is they just knew about 1951, ignored it because they knew about the prior cases and they knew about my letter. And their attitude is, sue us. And by the time they get around to suing them, then their attitude is, it's too late. And there it goes again. At some point, because this comes along, was there an investigation post, well, someone will have to write a letter or someone, write a letter. Last time I checked, a finding by the assignment judge of Mercer County that 21 county clerks violated election laws and didn't do what they were supposed to do should be enough, in and of itself, to invoke some form of investigation. I assure you it isn't forms outside of the Attorney General's office, but we're talking about what can be done between now and Election Day. This is an election for the United States Senate. Yes, I can bring an election contest, I can bring an election challenge, I can bring an election challenge to the United States Senate, based merely upon their wholesale failure to comply with the law. And quite frankly, I'm not sure what's going to happen, because we don't know what's going to happen on the 16th. That's still quite a week in politics is a lifetime. Depending upon what happens with certain things the FCC are doing, this could be a very, very different race, or it could be exactly what everyone expects. I don't know. But what I do know is the rules of the game are defined. They're cheating. I called them on it. Their explanation is, it's too late, it should have come sooner, this, that. Why am I supposed to expect that they're going to violate the law? The presumption is that they follow the law. And the presumption is that this court will then impose what the law requires unless there's no way to do so. Now, the question is, they're putting the wrong burden. Because once the court has found a violation, they should have to come forward with evidence to show show that it can't be remedied. The burden should shift at that point. I shouldn't have to come forward with evidence to show that it can be done because they're in a position to do it. How nice, I do know, because and again, Your Honor, we'll learn about this on your agreement. I've had the pleasure of spending a very long time with Mr. Pell. I know way more about these electronic voting machines than I need to, and I assure you, as we stand here today, I know a lot more than you. You'll know a lot more than you once you start your remand here. But this is no big deal. They've been holding elections in this country. We fought a revolution for it. We've been holding elections in this country for well over 200 years. There have been problems, there have been election contests. The first election in New Jersey, which took place over 2 days, not one.
Excuse me, I don't need to hear this, Mr. LaVergne. Do you have anything else that, I think that partly I've heard your arguments both now and
Yes.
and in
The pre-back that you're talking about, the pre-check that everyone's so concerned about, I'm not concerned about because now I know what that really means. That's included within the 48-hour time frame. The fact of the matter is, based upon Your Honor's findings and conclusion of law, the 21 county clerks violated state election laws, didn't do what they were supposed to do. Now they want to point a finger on me because it's too late to do it. They should be forced to come forward on a burden shifting saying that it can't be done. Because number one, I suggest that it can be done, so they should have to rebut that. I've come forward with a certification from Mr. Giles saying it takes 48 hours. They want to say that it's all sorts of things that are outside the parameters of that, and it's really not. Because as I was saying last Thursday, we're going to be here tomorrow at 2 o'clock. And it's going to be interesting to see tomorrow what we're going to say as to what the time frame between this, the October 16th election and the November 5th election, what really takes. Because I already know the dates. I read the papers. It's exactly what I've said. It's exactly what Mr.
I
Giles
don't think I
says.
need to hear anything else, Mr. LaVergne. Thank you. You may proceed. This is the court's decision on the application by plaintiff Mr. LaVergne for reconsideration of the court's order from October 3rd denying relief in the election case that he brought regarding the placement of candidates on the ballot for Senate for the special election scheduled for October 16th, 2013. The basis of the motion for reconsideration was citing new evidence. And the new evidence consisted of a certification from Robert Giles that was supported that was provided in support of the state's position back in June of 2013 when there was a challenge made to the governor's decision to hold a special general election for the United States Senate on Wednesday, October 16th, 2013, in order to fill the vacancy left by the death of former United States Senator Frank Lautenberg. And that case was Giuseppe Grillo versus Governor Chris Christie. And the Assistant Attorney General, Donna Kelly, has submitted a brief and appendix in that matter, and there's a certification of Robert Giles, Director of the New Jersey Division of Elections. And in that matter, there was concern that having an election on October 16th, so close to the general election of November 5th, would be prohibited in terms of complying with all the election laws. Now, as Ms. Kelly pointed out, I don't have the 53-page brief. I didn't make an effort to read it prior to today, but I did review the certification that Mr. LaVergne provided that was where Mr. Giles discussed the recheck procedures for machines after an election. But the concern was that there, at least as I understand, one of the concerns raised in the Grillo litigation is that could you complete the recheck procedures after the October 16th election in order to prepare the machines for the November 5th election? And Mr. Giles addressed that, and it was an admittedly tight time frame, 3 weeks between the two elections. But Mr. Giles assured the Supreme Court that the time for all the processes that he talked about, which included the programming of the machines, that they're going to do additional training training of staff, that the voting machines are straightforward design, there are instructions provided for their preparation, they're going to provide extra staff so that the voting machines will be prepared for November 5th within 48 hours after the process begins. And so that voting machine should be ready for shipment on November 2nd at the latest, and they're going to make available additional transportation resources and staff. So that reading the Giles certification, it's clear that voting machines can be prepared and delivered within a 4-day period, 2 for the programming, 2 for the transportation of all of the machines to the different voting sites. And I accept Mr. LaVergne's representation that he discovered the certification after the oral argument on October 3rd and seeks reconsideration of the court's decision that no remedy would be ordered for the statutory violation that he had shown had existed here in terms of the drawing of the ballot positions. And the court did find on October the 3rd that there, in fact, was a violation of the, I think it's 5.1 of the election law when Steve Lonegan was given a party place, the Republican Party place on the ballot, rather than being put in with the candidates who were nominated by petition. So the focus today is really on the remedy. And as I mentioned in the colloquy with Mr. LaVergne, the remedy that he requested morphed over time. This happens. You react to what the court is saying. You reacted to what I was saying. You reacted to what the adversaries were saying. But the fact of the matter is he came in and asked for the whole process to be done over when the mail-in ballots had already been sent out. A number of thousands of mail-in ballots had already been received with Mr. Lonegan having been given a party position. And some sample ballots as of October 3rd had already been sent to the post office, and others were prepared for mailing, at least based on the representation of the clerk in Lonegan County. In any event, the focus of today's application is much narrower than what the court heard on October 3rd, and the court is governed by the court rule 4:49-2 regarding motions for reconsideration, and this was certainly filed within 20 days, allotted by the rule, given the basis was provided, and Mr. LaVergne has provided new information to the court. I think that clearly the information was available. It was available from at least June 13th, whenever it was filed with the Supreme Court in the Rillo case. Even if it's not posted, you can make a request to the court for matters of public record, so he could have gotten it. As I'm accepting the representation of Assistant Attorney General Donna Kelly, that the brief that Mr. LaVergne cited in his own letter brief, that's the state's brief of June in the Rillo matter, he cited it, he had it. I'm accepting her representation that specifically addressed information that was in the Giles certification. So clearly, Mr. LaVergne could have cited the Giles certification to this court to show that the various kinds of relief he wanted, including he wanted a redraw and he wanted the machines program to be consistent with the redraw. He could have shown that the Giles certification last week, and it certainly would have prompted some additional questioning by the court back on October 3rd, but it's something that was available and he could have had. And his suggestion today that it wasn't an issue on October 3rd, the court is rejecting. I was looking at the feasibility of any relief, any and all relief, based upon the statutory violation. Mr. LaVergne, by his knowledge of election law, surely knew that the mail-in ballots to servicemen under the federal law had to have been sent out well in advance. And yet he asked in the original pleadings for the whole process to begin anew because of the problem with the drawing not being consistent with 5.1 as applied to special elections through the other provision of the election statutes. I can't recall if it was 1927-1. It might have been that. I don't have that right in front of me at the moment. But it's something that clearly could have been provided to the court. On the other hand, the thing that really motivates me more than anything else is what can be done or what should be done in terms of a remedy for what the court has found to be a clear statutory violation. So even though cases like Del Vecchio v. Penberger, 388, New Jersey Super 179, Appellate Division 2006, says the court should not grant reconsideration when the evidence was knowable, could have been found by the moving party prior to the time of the court's decision. I'm not going to rest my decision on that rule. Capital Finance Code v. Delaware Valley versus Astor Body, 398, New Jersey Super 299, Appellate Division case from 2008 is to the same effect. But frankly, at the time I decided the case last week, I really was balancing the various harms. The harm to the voting process by the violation of the statute that Mr. LaVergne had successfully urged the court to find that there was a violation. And I really considered at the time requiring additional certifications because in my mind I thought, I certainly considered that if the machines could be programmed appropriately, if a redraw could be done and machines be reprogrammed, that clearly was something that I was considering as possible relief. And I think, I'm looking at the notes now from the oral argument and from my decision, so I can't represent that I've listened again to the actual recording, and I do not have a transcript. But I did say I could require more certifications, but I viewed that there wasn't time for that it was really important for me to give my decision on October 3rd and weigh what I had before me on that day in light of the fact that the election was scheduled for October 16th. And so I looked at what was before me, and I don't believe, maybe Mr. LaVergne will be able to prove this otherwise, but I don't recall saying, and my notes do not reflect, that I ever found that the electronic machines could not be programmed in time for the October 16th election. I don't think I said that because I don't believe I had that information before me. I don't think Ms. Kelly, maybe even, I don't recall that she said it, because the defendants were responding to the request that the whole thing be redone, and then this additional request that everything be done by paper ballots, which was submitted at the same time as the supplemental brief that came in opposition to the relief the state seeking tomorrow regarding the rechecking of the machines, but also in regard to this case. So they were responding to something that then got changed in part by the court, by my questions, because I wasn't going to change the mail-in ballots and affect federal law, so no basis for that. The application was far too late for that. The court was even concerned with reprinting of the sample ballots in particular. I mean, provisional ballots and emergency ballots are a much smaller universe, but we had over 140,000 mail-in ballots already sent out with the configuration based on the original drawing. There had been, I think, over 60,000 ballots had already been voted and returned to the county board of election. So I was looking not only with what could, practically speaking, be done, but I was looking at what would the impact of that remedy be. And I was governed by a few things, and one of them, like I cited at the time, and that was the Supreme Court decision in Mochari v. Caputo, 100 New Jersey 119. And while that recognized the statutory right to draw a certain position is one that should be protected by the courts when it is impaired, in Mochari itself, when the court case was brought after the redraw, they said if it's brought after the redraw, it's too late. I didn't accept that as an absolute rule for this case because I wanted to get a sense of what the impact would be of requiring a reprogram of the ballots 13 days before the election. And when I heard that the sample ballots in 100 had already been sent to the post office, and that there would then be an inconsistency between the sample ballots and the machine ballot, if I ordered the machine to be changed, that there would be a redraw and the machine to be changed, I got very concerned about the impact on the integrity of the election itself. One of the county council raised the point that if a voter looked at the sample ballots, then the sample ballot could very easily just pick the number of the columns. Certainly the way it was set up, I think we had Burlington's sample ballot, and we had another county's sample ballot as well, and they were all, I guess two of them were lined up horizontally. Maybe there was a third I was shown that was lined up vertically, but it is an election for one office, the United States Senate. And so there was either a straight line horizontal or a straight line up and down. And I was concerned that there could be voter confusion if the sample ballot and the official ballot did not match. And Ms. Kelly today has pointed out that there is a statute that requires them to be the same. And so when we have the proven violation in terms of giving Mr. Lonegan the party position on the ballot that he shouldn't have had under the law versus the potential for voter confusion with the difference between the official ballot and the sample ballot, my balancing of that arm went in favor of the defendants and the right of the voters to express their preference and therefore to minimize voter confusion if at all possible. I noted that the real poll star from our decision was the right to vote of individuals versus the right to candidate to placement on the ballot. For example, for any particular county where Mr. Booker is in place one, it's possible that we could have the exact same ballot after a redraw. I mean, if by Mochari, I was guided by other cases that talk about the importance of preserving the integrity of the voting process and minimizing voter confusion. And I was also concerned with the weakness of the filing of the election case about Mr. LaVergne. It came, I mean, frankly, for the court's purposes, it was filed September 16th. I don't get copy of papers until the filing, until the money has been filed. So the money was all straightened out September 16th, and then I said that I thought it was a reasonable return date in terms of getting all the counties served with what appeared to me to be a significant challenge, and giving them the opportunity to be heard and to have a return date, thinking, I thought, that if October 3rd, I thought that it might be time for there to be at least some of the relief sought to be granted if a violation was shown. But after I found that there was a violation of 19:5-1 because of its of 19:27-1 that indicates that special elections are to be governed in the same manner as general elections, so that the 10% rule of 19:5-1 would apply to special elections. I nonetheless found that that it was too late for the relief to be granted. And I find that still true today. As I said, it was not a basis of my ruling that they could not change the machines in time. It was a concern over voter confusion and the fact that the sample ballots had largely been prepared, millions of sample ballots had been prepared and had started to be sent out. I even thought to myself, well, could there be, if we allowed the official ballot to be different from the sample ballot, they could put up a sign at all the polling places. Perhaps that would be one way to handle it, to at least alert the voters who read the sign that they had to look at the ballot and not to be governed by the sample ballot. I thought of all these different things. What could assure that the election be done in a way that met the law and still protected the administration of the election. And ultimately, I determined that the balance, as I mentioned, that determined in October 3rd, I determined it also today that the balance of harm is in favor of the defendants, meaning that injunctive relief to the plaintiff has to be denied. Some of this, I think, clearly comes with the timing of the filing of the complaint. I don't want to quibble with some of the representations that Mr. LaVergne made about his not knowing when the draw was, he sent out letters to the counties raising this issue, but once he sent it out, because again, I said until I think it was August 23rd, 22nd, or 23rd, when he sent those letters, the lawsuit wasn't filed until September 16th. He made certain representations to me about right to know act and lack of cooperation from Burlington County. He had the option to come to court to seek an emergent Oprah release in light of the sensitivity of election contests. And frankly, Mr. LaVergne has been involved numerous times before in election contests where the time sensitivity has also been very important. There was the case he brought in federal court, Judge, you mentioned it the last time, with Judge Wilson's decision at 900 F sub 2nd 447. And we know that failing to act promptly in election cases has been a basis for denying relief. That's absolutely clear in Moshari. And in Moshari, there at least the court had the statistical information about the drawings in Essex County and the drawings in Burlington County, the probability that they would come up so many times with the local party and whichever party was in charge of the county. I guess whichever party the county clerk was involved with, their party had always gotten the first slot for something many years, so that the probability was absolutely startling. Even in that case, the court found that it was too late. Where at least we had the statistical proof. In this case, we had no statistical proof from Mr. LaVergne. He cites Moshari and tells us what happened this year in Burlington and this year in Essex, but he didn't provide anything any further statistical information, despite his being involved in cases raising, election matters. Certainly. More recently in a federal case, and back, I think, in the Conservative Party, I think, versus Farmer. So Mr. LaVergne knew the sensitivity of the timing of what he was doing, and he knew a lot about the election process and the concerns of the court always in the election cases to prevent voter confusion, which can impinge the public's constitutional right to vote. Judge Wilson was really clear on that in the case that she decided. And she noted of New Jersey's important interest in avoiding ballot confusion and in ensuring the integrity of the election process. And that's at 900 F sub 2nd at pages 465 to 466. And again, the court had to weigh what is the damage to the plaintiff versus the damage to the defendants. And it is, perhaps technical violation is the wrong term, but Mr. LaVergne and all the candidates that qualify by nomination for petition are on the ballot. And in the ballots that I reviewed, they're on the same line as Mr. Lonegan and Mr. Booker. And although that was something that in the past was, I think the last time was another basis for Mr. LaVergne saying we should have been in a separate column for, for voters, nomination by petition, that seems to be abandoned now. He's just looking for a redrawing that removes Mr. Lonegan from the second spot and allows all of the other candidates to have the right to that slot. Again, it was a violation of the law, but when I look at that versus the confusion that can come from having a sample ballot that's different from the machine ballot, and the rush to try to reprogram machines, it would have been a rush, I believe, even on October 3rd. Could it have been done? As I said, I didn't rely on its not being able to be done, and even today, could it conceivably be done? I think probably if I ordered it, it would be done, but I don't think it's worth taking that risk to the voting process of rushing something through. Particularly, I mentioned this the last time too, when I know that there have been issues raised with the voting machines. Mr. LaVergne raised them himself when he argued for the need for a paper ballot, to then argue that the ballot placement and to order that the ballot placement, that the redraw be done, reprogramming the machines. In Middlesex now, with 25% of the machines having been sent to the polling places, to get them back, to reprogram them, if it conceivably could be done, I don't believe that it's appropriate to do it because of the risk to the election process itself and the integrity of the process. I also wanted to note that I think it was a case that was cited by Ms. Kelly the last time, McNeil versus Legislative Apportionment Commission of New Jersey, 176 New Jersey 484. The Supreme Court denied a stay there because the public interest is best served and harm to the voting public best avoided by ensuring certainty at this time in the 2003 electoral cycle, and consequently by maintaining the status quo. And that was done 3 months prior to the primary election at issue, and I believe that they found a statutory violation in that case. But the public good trumped the statutory violation. And, that also, again, in McKenzie v. Corzine, 396 New Jersey Super 405, delays in pursuing election litigation are something a court has to consider in determining the remedy, and it can preclude a court from fashioning a remedy in an election case because of the sensitivity of the electoral process. In McKenzie, there was a public question at issue and a concern about the interpretive statement of the belief, and that was what it was. So the closeness to the election was farther away than we are now. It was even farther away than it was on the 3rd. And the court nonetheless found that the plaintiff had contributed to the situation and by the way they had handled the litigation, and that it was not appropriate to grant the relief requested because of the closeness to the actual election. So here, now Mr. LaVergne has modified his request for relief to seek just a redraw, I say just, a redrawing of ballot positions in all the counties. Now he's saying just reprogram all the voting machines for every county. I still have harbor some doubts as to whether the law could be done in light of, Mr. Giles' June certification in the Grillo matter, assuming that all the legwork would be done for, in terms of configurations and so forth, would be done so that they could move within 48 hours to reprogram the machines. What Ms. Kelly describes as front end versus back end. I'm still concerned that about the 48 hours, but that's not going to be part of my ruling. My ruling is that the potential for harm to the voting process far outweighs the placement of the candidates on the ballot, since all of them have a place on the ballot. Therefore, the court will deny the application for reconsideration and rely both on the reasons I gave on October the 3rd and on the reasons added to the record today. And the court will issue an order simply denying the motion for reconsideration. And I'm not going to modify the order from the last time. My order today will just deny reconsideration. The briefs can be forwarded to the appellate division. They'll see what the arguments were, and they'll have my order to review if that's the course that the plaintiff elects to follow. So we'll make an effort, Emily, to just immediately produce the order that denies reconsideration.
Thank you. We're going to the Secretary of the Senate. My question is, two quick questions. Number one, did we file opposition papers besides the first law at 2 o'clock or no? Because I spoke to other people, they weren't even served. So I don't know what proof of service is filed.
I received a proof of service today. I was out yesterday, so I saw it today. I don't know when it came in. I personally don't know of any other filing besides yours. Did any come in, Emma?
Okay. And then my last question, since we're here, I'm in an unusually unique position of having prevailed and having a case dismissed. In the declaratory judgment aspect, you says, you said, yes, Mr. LaVergne, you're right. But in the back, you said, there's nothing we can do. That, under the global costs and the statute, means I'm telling you, my filing fee and all these costs of service and having these people run around the state to service award with that. How do I do that? Because the order that you're entering to have this, because you're saying it's dismissed. This is, what I'm trying to say is a procedural aspect.
You can file a motion for counsel.
A motion for it's just
that's true.
Just a file.
Right, you're pro se. You can file a motion for costs and opt to.
Because it's one of the county circuit, we're talking about, $2,000 plus. So at least I can be reimbursed for, required time.
I have to see your application and give the.
But you said yes, I just said yes, I believe I was asking for. It means I won from the statutes, they have to pay a filing fee and the cost of service, just total costs.
Well, you know what, there's no dispute as far as I'm concerned that you're prevailing on the law. I didn't look at any application for costs. It's something you may, I can tell you that in other areas, in Oprah areas, I have had the public entities agree without making the court apply for even counsel fees.
It's not a competition, it's costs. I mean, it was a $250 filing fee, a $20 filing fee, $30 more, and $150 expedition service to the 21 county.
My only point is that maybe you can work it out without filing an application. Perhaps you cannot. Sometimes that
I'll send the letter out, I would be surprised.
Okay, well,
They're not giving me a nickel without it. Don't kid yourself.
that makes it easy. Okay, thank you.
Thank you.